everybody, and welcome to our Fireside Chats. I'm Joyce Short, as you probably know, and my buddy Ellen Pollavy is joining us again as co-host, but we have a special guest co-host this evening. It's Dave Liston, and Dave is going to do a great job for us today because he's got super credentials for dealing with the district attorney issues. Dave, in fact, was an ADA under Robert Morgenthau. So got super duper background in this issue. And he also served as the chair for Community Board 8 and was also on the Civilian Complaint Review Board. So I think, Dave, welcome. And
thank you.
Thanks for being here, and we're really excited that you're here with us this evening.
I am so excited to be here as well, Joyce. Thank you for having me, and Ellen, thank you for letting me join you as well. It's really a privilege to be here, and thank you for putting together a program like this.
Oh, our pleasure. So also, let me introduce everybody to Dan Quart. I think most everybody probably knows Dan, because Dan's been with us for a while. Really slogged with us to help us with some issues here on Roosevelt Island, including our submetering issue here in Roosevelt Landings. But Dan has a long history of pro bono work for defending tenants' rights and public land. He's also been a volunteer for many years with the Legal Aid Society and helped with defending as a criminal defense attorney. But he's also, for many years, represented the Upper East Side and Roosevelt Island as a New York Assembly member since 2011. So now he's currently running as the replacement for Cyrus Vance Jr. In the Manhattan District Attorney's Office. So welcome, Dan, and thanks for joining us this evening.
Thank you, Joyce, and so glad to be here. And with I see so many familiar faces, and Ellen and Vicky and Dave. It's great to see you as well.
Super. So we're going to start with a couple of questions that we ask everybody that's joining us on our Fireside Chat. And the first one is, what decided you on going into politics? And for you, that's going to include also, what decided you on going into law and politics?
That, you know, when I was in college, I asked my dad, you know, what I should do. He said, well, you could be a history teacher like me. And I thought I'd be a history professor. But he said, you know, it's a tough life being a professor or a teacher in a public school. Go to law school. It'll be a better career. So I listened to my dad and went to law school. I went to St. John's for 3 years and came out and started doing pro bono work. It took 15 years to pay back my student loans, but I wish I could tell you I knew the day I was born I was going to be a lawyer and run for public office, but that isn't the truth. My commitment to run for public office first in 2005 for the city council in the district covering Roosevelt Island was really born out of my experiences going to law school and then doing pro bono work for those on the precipice of eviction through the Legal Aid Society's housing division. And as you kindly mentioned, Joyce, my work for tenants on Roosevelt Island themselves at then it was Eastwood, now it's Roosevelt Landings. And of course, with the Columbia Law School Environmental Clinic in our effort, there's no one on the call from the Octagon, so I don't have to worry, to try and protect open spaces on the island, which ultimately became the Octagon. So,
yeah, I remember that fight.
I have a long history, not just in the legal world, but in my legal work specific to Roosevelt Island.
Excellent. And so now let's get to your platform a bit, Dan. Can you tell us what your most important topics are that you know, what do you believe to be the most important topics on your platform, and what do you intend to do about them?
It's an excellent question. Let me start in the general, and then we'll have the next 40 minutes to talk in the specifics. But really, we can, this sort of false choice, we can have both reform of our criminal legal system, but at the same time, a sense of public safety that is required. Any DA who has to be concerned about public safety issues. But it's redefining how we do that without punitive practices that discriminate against typically communities of color, but poor people as well. And my experience in the legislature has been about decarceration, especially on issues that have no negative public safety consequences. And we can do that through declining to prosecute certain crimes were indicative of poverty rather than of criminal intent. At the same time, reallocating resources to that which does make us less safe. And I'm talking about certain violent crime, gun crime, as well as sexual assault and rape. And I know we'll talk in greater specificity about that, Joyce, during the course of this call. Something and cybersecurity crime, which is not dealt with in the way that it must be. Confidence scams, credit card scams, phone scams, which are so pervasive throughout Manhattan and New York City on our elderly communities. So it's about the right balance in finding the office, but it's about a clear-cut vision of reform of this office, because I have been dissatisfied with Mr. Vance's performance as district attorney. And if I thought another prosecutor would reform the office, there's 5 of them in this race, I wouldn't be running. But I think an outsider's perspective, but someone with my set of experiences, both legislative and 23 years of litigation experience, including several years in criminal defense work, is the right set of experiences to reboot this office, if you will, to something that's more responsive to communities in Manhattan.
So I know you had mentioned, that you want to cut the footprint of the DA's office. Can you be more specific about what areas you'd like to cut? And are there other areas that you'd like to expand?
Yes, I have a list of 18 specific charges, which are probably more vast than that, because it really deals mostly with drug possession type cases, which we've taken some steps in the legislature for decriminalizing marijuana, but I think it even goes beyond that to different drug possession cases. And then also certain cases like driving with a suspended license. I'm not talking about DUI or DWI. I'm talking about tinted windows. For historical reasons, things like this have been elevated to the criminal court. The problem is 80% of car owners, 76% of car owners in New York City are white, but 80% of those who are prosecuted are people of color. So something discriminatory is happening. The words of the statute itself are not discriminatory, but I look at those practices and I say they're not salvageable and they ought not to be prosecuted, which is not to say they go away. There'll be a civil summons, but I don't think they're deserving of being elevated to the criminal court where you can do real damage to a person with a conviction. Secondly, what needs to be expanded? I was the first candidate in this race to put out a 9-point plan on how I would revamp the sex crimes unit within the office. And I think we'll talk, we'll talk in greater detail because that deserves its own question and answer on that.
You know that's coming.
But also I talked about cybersecurity. That's one place where I would expand the office. Right now, the DA's office only deals mostly with joint investigations with the federal Southern District, or on rare occasion, the Eastern District, because they're dealing with large scale enterprises. I would change that and reverse that to smaller scale enterprises, those people who steal through credit cards or phone scams or something else too, $5,000 to working people. That's what I want to focus on. In turn, those are usually larger conspiratorial nets, but I would get after that through dealing with the smaller cases and let the Southern District deal with the larger cases. I think that's what a Manhattan district attorney should be dealing with. Those are some of the places I would expand the footprint of the office, where I don't think enough resources or person power is being dealt with, as opposed to those lower level offenses, which are punitive, carceral, and in most part don't provide much of a public safety benefit to anyone.
Mm-hmm. Excellent. So Dave, I'm going to turn the torch over to you. You got your torch over there?
Yeah, I've got it.
Yes, we are serious about being by the fireside here.
Joyce and Ellen, thank you again for having me on here as a guest interview. And Dan, it's really great to see you. As some of you know, Dan and I were on the community board together for many years. And I've had the privilege of working with him on the board, seeing his great work then, and then watching his career develop. And I'm also a constituent, as are many of us. So I want to thank you, Dan, for all that you've done and continue to do on behalf of our community.
And to be fair to, Dave deserves that credit as well. I served under his leadership on the community board, and his incredible work in the community for his local church should not go unmentioned. Dave gives back more than most to his community. So thank you, Dave. It's good to see you.
Thanks, Dan. So I thought, I think a lot of times when people run for office, they try to distinguish themselves, as well they should, from their predecessors. I'm going to turn that around a little bit. As you know, Robert Morgenthau was the district attorney for over 35 years. Manhattan has had really only 2 ADAs for the last almost 50 years. And the office, if I may say so, is pretty well regarded around the country and around the world. There's a lot of good things that have happened there over the years, as I'm sure you would agree. And so I'm going to ask you this: when you look back on the service of Robert Morgenthau, and then more recently Cy Vance, are there aspects of how they shaped the office that you would like to continue or build upon? And if so, can you give us some examples? And of course, I'll ask the related question.
Sure.
How would the office most distinguish itself under your leadership compared to the prior 2 DAs?
It's only fair to judge people through the historical lens in which they live. Now we're talking about progressive prosecutors, a more decarceral model, but that wasn't the time or era that what he set forth was a standard of integrity that not just any Manhattan district attorney has to match, but district attorneys across the country, and how he ran that office beyond reproach. And there's so many policies that he put in place that still remain to this day and basically are unchanged, and for good reason. I mean, he was forward thinking. One thing with and Vance was elected mostly, what's a fair equation, in the footsteps of Mr. Morgenthau. And one of the things I give him credit for is he has this the DA's office has this huge pot of money called the forfeiture fund pot. And I won't bore the listeners by going into how that's accumulated. But Mr. Vance put in certain protocols that are really significant because they involve an evaluation process, a grant approval and rejection process. Vance chose smartly to put a system in place that while he could advance certain principles he wanted in who received these grants, that he did not pick the winners and losers. And I think that stands and speaks well for Mr. Vance in understanding something that he did that he was not statutorily required to do. So I think he deserves credit on avoiding what would have been a pitfall had he not done that.
Okay. And how would the office most change under your leadership? It sounds like you've identified a number of things about your predecessors that you would hope to continue. How would you most change the office from the 2 prior DAs?
There was less of a vetting process in the early case assessment bureau, mostly because they were concerned with NYPD officers wanting to be there to get time and a half. There was an overtime problem. So they really allowed, in my view, the early case assessment bureau to not be the vetting function of initial NYPD information that it needs to be. And Mr. Vance has not at least made that assignment a primary assignment in the office, rotating people in and out of the early case assessment bureau. So they can't get the expertise in vetting police officer information as they should be. And I think police accountability is public safety and a big part of why I'm running. So that is a small critique, if you will, on a very mechanical issue that I think has great policy significance. Secondly, with Mr. Vance, on mental health issues, I don't agree with his approach that essentially before he provides or offers alternatives to incarceration for someone on a mental health charge, most of the time a felony, not a misdemeanor, but on occasion a misdemeanor, that he requires that individual to plead to the top count before he or she gets an offer of the mental health services they provide. I disagree with that approach. I think often so many people have mental health issues, it's important to treat that mental health issue and not worry so much about whether the person pleads out to the top count. Let's get the person the help they need through the non-for-profit provider. It's a specific one called Cases. It has a wellness center on 125th Street. We can always keep the case active and reevaluate after the person has completed their 90 or 100-day medical treatment. I don't think we should extort a criminal conviction out of someone to get the mental health services, which is likely the reason why they're in the courtroom in the first place. So that is two areas of distinction between my two predecessors and specifically Mr. Vance on policies that I would reverse.
Okay, and while we're making distinctions, let's talk about I believe it's 8 candidates in the field at this point.
8 of us together. Yeah.
8. Okay, it's a lot of people. How would you best distinguish yourself from the other candidates?
Well, the press has sort of made it 2 buckets, the prosecutors and the non-prosecutors, but I think that's a little, that's not the specific. I would almost see it as 3 buckets, the 5 prosecutors in this race, the 2 non-prosecutors, and then my own bucket, because I'm a legislator, a practicing attorney, a civil experience, as well as criminal defense experience. That is different than the 2 non-prosecutors in this race. But the press has written up to the extent they've covered this race in the prosecutors versus the non-prosecutors. But I don't believe that at this particular time in history that a prosecutor is the right person to reform this office in some of the ways I've already described in the call tonight. I think I have the right outsider's perspective to make both policy changes and equally important personnel changes within the office. And I'm happy to talk more specifically about some of the personnel changes I would make that would be non-political, but I think would go deeper than just changing of the leadership team, which is just what Vance did when he came in from Morgenthau. He just changed the leadership team for the most part, then some changes of bureau chiefs in the successive 4 to 6 years. I would make deeper and more significant reforms and personnel changes than that.
Well, Dan, I think I'm allowed to ask you 3 questions, but you sort of gave me the third just now. You talked about making some changes to the personnel within the office, the structure of the office. Can you give us a little bit more detail?
Yes. And it's not about name changes of the different departments. It's about bringing synergy. And I have a whole plan about recruitment, retention, and changes. But let me give you one example on drug crimes. So, and this is this is where management of the office, and David understands this, but all of you who've been involved in management will understand this. Let's say there's a drug-related arrest. It could go to one of 3 places if it comes into the Manhattan District Attorney's Office. There's a separate office called the Special Narcotics Prosecutor. This is a relic of 1971, and in certain cases, drug mills, and Dr. Pill cases would go to the Special Narcotics Prosecutor. Separately, if the drug case involves a quote unquote gang member to be determined in an unspecific fashion, it would go to the Violent Crimes Department. Lastly, a standard run-of-the-mill drug case could go to any one of 6 or 7 trial bureaus, trial bureau 30, 40, 50, 60, 70. What you were describing, though, is a case with the same arrest could go to 3 different places, 1 outside of the office, 2 within the office. And that brings to wildly divergent results. So my plan is to bring synergy within that system, because anyone arrested on a specific drug case, which we are going to prosecute, should have the same result. The results should not vary by which department he or she comes into. And this is a management issue about bringing a singular system within the office on how we deal with drug cases. So these are the things I've been thinking about. I know it's very technical, it's very inside the office, but it's how I achieve my results on decarceration and basic fairness, because 2 cases that are similar in facts and arrests should not be treated differently. Right now, they very well could be in the Manhattan DA's office.
I mean, let me just challenge you on that, Dan. We actually know that no 2 cases are alike, right? No 2 defendants are alike. No 2 victims are alike. And someone could be selling drugs completely on their own. It's a one-hit wonder. They do it once or twice. another person could be a member of a violent street gang committing lots of crimes, and drug dealing being just one of them. And a third person might be sort of a career criminal, someone who's done it over and over again. Do you not see any reason or benefit to potentially treating those individuals differently and sending them to a unit that might be particularly equipped to deal with the special circumstances of each case?
Of course, and that's why I was not talking about disbanding the unit.
Okay.
I was talking about synergy of protocol and processes within the units where there's identical subject matter or identical arrest records. But yes, you are right. And every individual who comes into the office is his or her own person, and you judge that individually. You take that person's situation into account, what their circumstances might be. And if they are engaging in violent conduct as part of a quote unquote gang, I would prosecute them. But I would prosecute them for what they do, not their affiliation. There's certainly no shortage of felony laws on the books where if a person is involved in a gang, that I do not have the wherewithal or the bandwidth to prosecute that individual for a felony under the penal law. As you know, David, penal law section 7002 is expansive and allows for many different charges. But similarly, if we're dealing with first-time drug offenders or drug offenses and they get involved in gang conduct because they're 15 years old and their 18-year-old cousin was involved in a gang, I want to treat that person differently as well. I want to avoid the criminalization and conviction of that person if possible, because ultimately that criminal conviction is such an obstacle to future employment, and can get kicked you out of a NYCHA complex, rendering you at a young age homeless. So there are so many factors to consider. Dave is right. But in my explanation, I was talking about bringing a sense of synergy between the different departments. Not that every case must be treated the same, but cases involving the same type of issues, we should be treating them similarly.
Okay, thanks, Dan.
So now
I think I need.
Yeah, we're going to pass that torch. That's going.
Here we go. Ellen said to Ellen.
Yeah, here we go. Here we go. Okay, so we're going from someone who knows everything about the DA's office to someone who knows nothing about the DA's office. Thank goodness. So I'm going to ask just one question, and it's kind of like a multi-pronged question, Dan. And I just want to know, as someone who lived through the bad 70s and 80s in New York City when crime was rampant, I think this is a question that a lot of us older folks have, where we don't want to return to that time. So when we're talking about maybe a little bit of more leniency in dealing with people who've committed crimes, we're talking, we worry that maybe this will mean we're returning to the bad old days when crime was rampant. So how can you assure us that your very thoughtful ways of treating people who have committed more minor crimes will not result in people feeling emboldened to commit bigger crimes? I'm not even sure if I'm asking the question, but I just want to make sure that whatever you do doesn't send us back to bad times.
And nor would I allow us to. There's two answers to that question. One, I will prosecute. I'm running to be the prosecutor, and that requires prosecuting many crimes, including many violent crimes. And I will. And it's in the interest of 1.6 million Manhattanites that those who engage in violence on our streets, and that's just one aspect, violent crime, that they are held to account. That is different than overly long sentences, which are punitive and really fleece the taxpayer. So there's a difference between accountability and prosecution, which I will do, and then sending somebody away for 40 years or 50 years, which I won't do. Secondly, on the idea of, and Ellen, you and I have met people within Rivercross who made this very argument to me, and it's worth exploring that broken windows policing, that if we arrest people for the small stuff, whatever one defines as the small stuff, that will prevent them from committing larger criminal conduct in the future. I simply don't agree with that assessment. The Department of Investigations did an expansive study in 2015 about broken windows policing, and they came to the conclusion that there was absolutely no evidence to suggest that low level of arrests changes, ameliorates, or prevents future violent criminal conduct. A lot of people disagree with me. A lot of people believe on faith that that is an acceptable theory. I don't think it is. I don't believe it works. I think it elevates the levels of tension between our police officers and our communities of color. I think we lose more than we gain. But there are certainly candidates in this race who have an opposing point of view. And I think it's fair to tell my friends on Roosevelt Island that that's just not something I believe in. The data suggests does not demonstrate a connection between the two. But that being said, there are certain people who still believe that theory. And there are candidates in this race for them who would likely be more consistent with that view, certainly than I am in this race.
Well, that, do you feel comfortable talking about which of those candidates are those people?
I think they're mostly within the 5 prosecutors in this race who are, they're varying degrees of difference, but having been on 25 Zoom debates with my other candidates, we all really have a basic understanding of where they are. But unfortunately, Ellen, we can't expect the voters to participate at that level. I mean, look what the voter on Roosevelt Island has to deal with. A primary for district leader, a expansive primary for city council, a primary for borough president, comptroller, mayor, and district attorney. If you were to, all you would do would be on Zoom calls all day long. So it's very hard on the voter this year. It's to pay as much attention. So we talk in intricate details about the district attorney's office, but it's unfair of any of us to expect the voters to pay that much attention. But I would say in a general sense, the former prosecutors, the 5 of them in this race, are closer to that vision on broken windows. Not all of them, but certainly I don't subscribe to that view.
And I know that the defenders, the defenders are look at the DA's office as the ones that are going to do the least harm to the accused people. So do you think that you're one of those people that are going to do if you're the DA, would you do the least harm to the accused?
Well, I interviewed with them and they set up their list and their criteria and they used their language on least harm. And I think what I'm most proud of their write-up is they identified me as a candidate, not only who would do the least harm, especially to communities of color, but that I had the most specific plans and of all the candidates that they rated highly qualified. And that's what I'm most proud of, that I have specific policy proposals. I've studied these issues. I've come to conclusions based upon my work in the legislature. And I think Manhattanites want a district attorney who has not just a vision, which is important, not just rhetoric of reform, but actually knows and has an idea of how to use the office as a vehicle to achieve that reform. And that's why I put out plans specific and plans I've written or legislation I've written, not just hiring a consultant to put out things on a website, but things I've been talking about. And Joyce knows we've been talking about these issues on consent and sexual assault for years. And my knowledge base comes not because I had to hire a policy expert to brief me on them, because I know the legislation and I know what the Rape 1, Rape 2, and Rape 3 statute says, because I've studied them and I've challenged Vance when he's distorted their view, in my estimation. So it is sort of my lived experience through legislative life and in the courtroom that I think the 5 borough defenders rated me as the person who will not only do the least harm to communities of color, but has the most pronounced and detailed plans. And that's the part I'm most proud of.
Right. Thank you.
Ready to pass the torch?
I'm going to pass the torch to you.
Coming back to me, yeah. So I'm glad you brought up the sexual assault side of the issue here, because I want to get into that a little bit more deeply. Dan, can you tell us what bills you've authored or sponsored related to sexual assault since you've been in the Assembly?
Well, it's really one specific issue right now that I believe Assembly Member Seawright either is or has it put forth the bill defining consent.
Yeah, it's there. It's been introduced.
And I am
A6540.
Yes, I am a co-sponsor of the bill. Was supposed to be. I will double check to make sure that my name appears. If not,
yeah, it didn't. It didn't. I know.
Well, I told Assembly Member Seawright to put my name on the bill, so I will call indexing tomorrow to make sure. But I am a supporter and a sponsor. But this is an important piece of legislation because there is no standard of consent. Judges advise juries to use their common sense, but this is not an area where most lay people have common sense in this, and it's through no fault of their own. It's not because they're unthinking or unwise, but understanding what is and what is not consent in the context of sexual assault and rape is not a common sense issue. And it shouldn't be left to the lay opinion of 12 Manhattanites or 14. It should be defined in law, and that's what this bill does. And I think that's a significant, important piece of legislation, and one that is not supported by all the defender organizations that speak highly of me. But I think it's the right thing to do, and I support that legislation, and we'll push for its passage. So when I'm district attorney, I will have written guidelines that I can give my ADAs. But even if this bill is not passed, the bill still provides a roadmap in training my ADAs who work in the sex crimes unit on how to question jurors during voir dire and how to seek jury instructions at the end of a trial. So at a minimum, the memorialization of this standard into law or in a bill provides a roadmap for the next DA on what to do in this critical area.
Well, I'm certainly glad to hear that, Dan, because I think it's going to take a lot of effort to get it passed. Just like anything else, when something is new, you get a lot of pushback until it's finally accepted. And so I don't think that this is any less contentious.
No, but
yeah.
They haven't met you yet, Joyce in Albany. So they
actually they have.
They have met you.
I've been there. Yeah, but the other thing that I was wondering, the involuntary intoxication bill, that's been stalled in the Assembly. It passed in the Senate. What can you do in the Assembly to get that passed? And don't you think that's an important thing to do before you leave the Assembly?
Is that Senator Biaggi's bill?
Yeah, that passed in the Senate. But
there are some questions about this bill, and I have to be honest with you, Joyce. And let me this is a very technical explanation, but this was in a case. These are in cases of voluntary intoxication, 9 out of 10 times, where a man preys upon a woman because she is intoxicated, he got her intoxicated, or took advantage of his situation. Currently, there are 3 different statutes under New York law dealing with rape. Rape 1, Rape 2, and Rape 3. Rape 2 came into an effect, and maybe David can correct me if I'm wrong on the specific dates, I think in the 1980s, or was amended in the 1980s to deal with the phenomena of men putting chemical substances in women's drinks. So it was specific to drugs. And it was meant specifically for drugs, not alcohol. Typically, when there's a rape case or sexual assault case, a rape case, let's say, where it is involving alcohol, the indictment is brought under Rape 1 or Rape 3. And those cases have been indicted and prosecuted by district attorneys in New York State successfully for years. Cy Vance botched the case. a voluntary intoxication case was brought under rape 1. We know that because his office secured an indictment. During the plea bargaining of the case, instead of a plea bargain to rape 3, he plea bargained the case to rape 2. And the appellate court said, no, you may not do that. Your ADAs made a faulty plea agreement. You can't take a voluntary intoxication rape case and plead it out under rape 2, which deals only with chemical substances. What they should have done was pled out the case to rape 3. This is a long explanation of how the problem came to the attention of the legislature on this case. Cy Vance, to my estimation, disingenuously said, no, it wasn't my office's fault. It was a problem with the language of the law. The language of the law may need to be updated, but Cy Vance was not being truthful in that statement. There is no problem with the rape 1 statute. There is no problem with the rape 3 statute. It has been used successfully hundreds of times to convict people who have raped other people, men who have raped women who are under the influence of alcohol.
In a voluntarily intoxicated way?
Yes. And there is specific case law showing that pattern. Senator Biaggi's bill takes the rape 2 statute and makes certain amendments that allows voluntary intoxication to be a factor under a rape 2 indictment and prosecution. So I'm not saying her bill is not a good bill or its wording, but it is not technically necessary to secure a conviction under a voluntary intoxication fact pattern. It is the will of the prosecutor. Mr. Vance was disingenuous with the public when he blamed the legislature for poor language that limited his choices. It wasn't poor language. It was that his office botched a plea agreement by doing a plea agreement under rape 2. All that's needed is the will to go after these cases, to deal with them seriously. And Mr. Vance has secured conviction on voluntary intoxication patterns under rape 1 or rape 3, and other district attorneys as well. So blaming the legislature was deeply unfair and wrong to victims and wrong to advocates. Now, we can debate whether Senator Biaggi's bill is a needed bill, a good bill. Senator Biaggi is an incredible partner and a great legislator. But there is nothing wrong with the current rape statutes that prevents me as the Manhattan District Attorney from prosecuting overwhelmingly men who rape women because they overserve them or they take advantage of intoxicated women.
Excellent. Yeah, very interesting take on that, Dan. I'll have to look into that seriously. So let's switch the subject up a little bit. I think a lot of people hear the word restorative justice and are really not that familiar with what that entails. And I think that some people are concerned that there may be people that are forced into a kind of a sort of a, meeting of the minds kind of thing, having to do with really significant crimes that have happened to them. What can you tell us about restorative justice and how you would implement that kind of approach in the district attorney's office?
You're absolutely right, Joyce. I think no 2 words have been misused more in this campaign for district attorney than restorative justice. It's like apples and oranges. People talk about restorative justice like it's an alternative to incarceration. Like you go to drug court and you get mental health or drug treatment at an outpatient and you don't get charged with your crime if you complete your 12-step process or something like that. You can't hoist restorative justice upon anyone. Restorative justice is a concept that goes back to Native Americans, the concept that the harm done was to the entire community or the entire tribe, and that only the solution by the entire community can work. It is a great principle, but it only works if all the parties want to be involved in it. And it can't work for all violent crime because certain violent crime, it's my determination and my decision to hold that person accountable. That even if the person, I would maybe take into consideration what that person wanted, if he or she wanted a restorative justice process. But at the end of the day, my responsibility is to make decisions what's in the best interest for 1.6 million Manhattanites. And that's taking into consideration what the victim wants, but not always heeding that person's request. Sometimes you have to make the tough call and say, sometimes this individual must be prosecuted, and it's for the good of the community. Restorative justice program, there are great programs out there that do this, even in gun-related crimes, but it takes place mostly outside of the courtroom and outside of the jurisdiction of the Manhattan District Attorney's Office, because just by its definition, you can't have restorative justice because that requires somebody admitting that they did fault. What defense attorney would allow their client to essentially admit to the charges under a restorative justice program where they could still be convicted? It just doesn't work that way. It works in a different way, but it's been used as part of the phrasing of different candidates in this race, and unfortunately not properly explained in its proper context. I believe in restorative justice. It's critical. I think it saves people from unnecessary jail time depending on the harm, but a lot has to do on the victim and his or her willingness to partake in that process. And it's not something that can be used as a catch-all phrase to fix every problem short of incarceration.
Mm-hmm. I noticed in your platform where you're indicating the things that you won't prosecute. One of them stood out for me, and that was loitering for the purpose of gambling.
Yes.
Because we actually do have that problem here on Roosevelt Island. You mentioned that you're not going to prosecute busking and soliciting, prostitute soliciting.
Yes.
Yeah, we don't have those problems. We do have the problem, however, of loitering and for the purpose of gambling. We have the, gangs of people that, just kind of hang out behind Roosevelt landings, gambling. And unfortunately, it creates fear for the people around. Not only that, but it also makes a mess. These people are back there littering. They're playing dice. They're rowdy. They're making people concerned, especially elderly people that have trouble getting by. What do you think we can do about that? Obviously, if you're not going to prosecute them, does that mean that the public safety department are not going to intervene and move them along, or we're going to deal with that issue?
What is public safety on the island doing right now to address
that?
So the law's on the books and they're doing nothing anyways. Loitering for the purposes of engaging in gambling has been used, unfortunately, as a predicate statute by police precincts, specifically the 23rd and the 25th in East Harlem for years. So it's been a significant problem how the loitering statutes have been abused by the NYPD to make predicate arrests. That is the genesis of why I decided on this specific crime charge I would not prosecute. That being said, there's about 17 different loitering statutes, and if public safety on the island or the 114th is intent on arresting these young men, they certainly don't lack in the criminal statutes for doing so. But this is a specific way that has been abused in East Harlem and Washington Heights by the different police precincts, which is why I included it on my list to decline to prosecute. But you bring up a valid issue of policing and public safety on the island and the difficulties and complexities of having a police precinct responsible for you that's located in Queens, and an over-reliance on a public safety department that, going back to my first race for the city council in 16 years ago, was not accepted as a really responsive force, except for, Ellen can correct me, the gentleman's name, during a short period of time where that gentleman, I forget his name, was in charge of public safety.
Jack McManus.
Yeah.
Jack McManus.
But look, I do know something about the island and its specific problems, and from having canvassed I still call it Eastwood and I still call it Trellis, whether in Rivercross and Eastwood, in Westview, I know the island, and I will not, if I get elected, I won't disappear, and we'll deal with these problems with alternatives for young people. It's really about providing opportunities for young people through social services, through opportunities Bob Morgenthau was a giant with the Police Athletic League in trying to provide these opportunities. And Cy, I'm not noting, Cy has continued in that, but I want to expand those opportunities for young people so they have a place to go and things to do when it gets cold outside and they're not out there loitering or involved in gambling and doing things which we all know is not in their best interest. You have to give these young people an outlet, an opportunity of something else, especially when it's cold out, to give them the space. The good thing is Roosevelt Island has those spaces, and I would want to invest some of that forfeiture fund money through a screening process for some of the non-for-profits that do such good work on the island. But I would not be a stranger to the island. I think everybody who knows me knows that I would not disappear after Election Day, that I would keep coming back to deal with these problems personally.
So I want to remind everybody that we have a chat, and if you have a question that you'd like to put in the chat, we'll try and pose it to Dan before we leave. I've got one more question I wanted to ask you that I know it's probably top of mind to people that see, reduction of or elimination of cash bail as an issue. How are we going to expect people to return to court for their trial dates when there's no cash bail requiring them to do so?
85% thereabout return to for their hearings. And the reason why is most are poor and they know if they don't show up in court, there'll be a bench warrant and they'll get picked up eventually anyway. So the overwhelming majority of people return to court because they know there's no alternative. The idea that they're going to LaGuardia and getting on a plane and flying to a different jurisdiction, that's for Law and Order, the TV show. That's not real life. So we have a system, and this is where the Mayor's Office of Criminal Justice, which runs the not-for-profit providers that provide pretrial services, has actually done a good job through check-ins, through beepers, through supervisory services. So we have a system in place currently where 8 out of 10 or close to 9 out of 10 people ultimately return for their court dates, either because they know it's the right thing to do or more likely they know there's no alternative. Mm-hmm. They're poor, they're not going to leave the jurisdiction, and they'll be walking around with a bench warrant and they're likely to get picked up and then they'll be sent to Rikers Island. So we have a system in place that speaks to that 15%, not the 85% or thereabout who return normally. What I want to do is to get the money portion out of it. If you're an individual who's charged with murder one, I don't want to put bail on you. What if you have a rich uncle who can post bail? You're going to be remanded. There'll be a rebuttable presumption that you'll be remanded. If you're an actual flight risk, and my ADAs can present evidence to that effect, then you're a flight risk and you should be incarcerated. If you're a physical threat to another person, not some nebulous standard of dangerous, but an actual threat to another human being, I'm not going to put a dollar figure on it. I want you to go to the Tombs or Rikers Island until we expedite your trial. So my concept is take the money equation out of it. Why should it matter whether you have wealth or not, whether you're locked up? We should be looking at the seriousness of the charge, whether you're a physical threat to another person, and whether you're actually a threat to leave the jurisdiction.
Great. Dave, Ellen, any more questions for Dan?
I defer to Dave.
What's that?
I'm deferring to Dave. Do you have any questions?
Dan?
One more, Dave. Last question. How's that?
Last one. And this will be a quick question and I think a quick answer. Dan, 3 words for why you should be DA.
Change with conviction.
That's good.
Okay. You only gave me 3 words, so I couldn't say change the office with conviction.
Thinks on his feet.
Okay. That speaks to what I want to do. And no, I really think my experiences in public life, and I include the community board because as many who have served gave me great training for this moment. As an elected official on the community board, you're forced to be in the public eye. You're forced to take votes. You're forced to take public positions. And I've done that for 8 years on the board, 10 years in public office, 6 elections in the last 10 years. That is one distinguishing factor between myself and everybody else running for this office, a bunch of very good lawyers. I've had to defend my views before actual voters, some who agree with me on things, some who disagree with me. And I think that's an important skill you want with your next district attorney. As Dave can tell you from having served in this office, this is one of the hardest jobs in public life. After being governor and mayor, I think being Manhattan district attorney may be the third hardest job in New York State. And it may be one of the hardest jobs as a district attorney in the entire country, with Los Angeles County and Cook County in Chicago. And I think I have the right blend of practical litigation experience. I've been a real lawyer for 23 years, representing real clients, not at firms where I could not try cases or just do document review. Real litigation, real experience, and been in the public eye, taking positions and defending them, and not always popular positions. And I think those are the qualities you want in a district attorney, because this is not an easy job. This is a difficult job, and it's one where you really have to accept a level of conflict and negativity by the press in your life. If you want to be liked, there are better jobs to do in political life than being district attorney. This is one which you win, you accept the bows and arrows of negativity that come, and most importantly, you protect the office and the lawyers so they can do their job in an apolitical setting. And that when there's politics involved, that you're the one being criticized, but you shield the lawyers to let them run and be the law firm to execute on your vision. That is a significant aspect, and it is not a job for the faint of heart. Sometimes my wife questions why I want it, but I think at this particular moment, I can do a good job being the district attorney for all Manhattanites, whether they agree with me on every single one of my policy positions or not.
Excellent. Well, Dan, we thank you so much for being here. It was lovely having the chat with you. And I wanted to remind everybody that the elections take place, or our votes will all be recorded on June 22nd. And your vote is your voice. And we want to hear it loud and clear on the 22nd. I see Ellen's got her hand up. What did I miss?
Dan, can you explain the difference in the voting, in the way you're going to be voting for DA versus everybody else?
Maybe the most important thing, every race this year, other than the district attorney's races and uncontested judge races, will be ranked choice voting. So for your city council member, your city council candidates, you can rank all 5 of them. And I'm not even going to suggest who should be 1 and who should be 5. But in every race on a particular ballot, you'll have ranked choice voting, except in my race. You can only vote for 1 person because mine is a state office. So to further complicate matters, you'll probably be getting 2 ballots when you go to vote. And unfortunately, there's no early voting site on Roosevelt Island, which is a point of frustration for, I'm sure, Roosevelt Island residents, that you have to take the tram or the F train to come vote early, which should be unnecessary with the amount of people on Roosevelt Island. But that being said, if you vote on June 22nd at the school or anywhere else you can vote on the island, you'll be getting 2 ballots, 1 for all your city races and 1 for this race and any judge race and district leader race, which you have as well. So 2 ballots this year.
Excellent. Okay, folks, so we hope to see you on Wednesday. On Wednesday, we actually are going to have another district attorney candidate. Lucy Lang is going to be joining us. So we hope to see everybody back on Wednesday. So until then, folks, we're going to blow out the torch, and we'll see you soon. And again, thanks very much, Dan, for joining us.
Thank you.